On July 13, 2015, Governor Brown signs a law to clarify employers' obligations under the new California paid sick leave. The law answers some questions, but there's still a lot of uncertainty facing employers going forward. Welcome to the California Employment Law Report. This is an update regarding the new amendment that Governor Brown signed regarding the California paid sick leave on July 13th, 2015. The amendment that he signed went into effect immediately, and its intent was to clarify some of the issues that faced California employers regarding the new paid sick leave law. So therefore, the amendments apply to employers as of July 13, 2015 and going forward. And I wanted to briefly discuss some of the clarifications that this new bill put into place for the paid sick leave law. First, the amendments made it clear that employers may now use a different accrual method other than the 1 hour of paid sick leave for every 30 hours that the employee worked. The new law, the amendment signed into law by Governor Brown, basically says in order to simplify the math for employers, that employers may now use a different accrual method as long as the accrual method is 1, on a regular basis, and 2, the employee has no less than 24 hours or 3 paid sick days or time off by the 120th calendar day of employment. So if the employers have already enacted a paid sick leave law and they're accruing the 1 hour of paid sick time for every 30 days or for every 30 hours that the employee works, they can continue to use that accrual method, or they can look at this easier, potentially easier accrual method put in place by the new law. Second, the amendment made clear that if the employer pays out any accrued paid vacation at the time of separation that the employee separates from employment, if the employee comes back to work within 1 year, the employer doesn't have to give the employee the paid vacation, the paid sick time that was paid out previously. So the employee would therefore start with potentially zero paid time off and have to start accruing that time going forward. Third, the new law clarified that if employers provide unlimited paid sick time or paid leave, that on the pay stubs the employer could put unlimited under the line for paid sick leave, and that would meet the reporting requirements for the itemized wage statements. Fourth, employers now have different options for calculating the amount of pay owed to employees while they're taking the paid sick leave. Under the original enactment of the law, employers, there was a formula that was proposed for employers that had employees that received fluctuating payments or fluctuating pay. And under that formula, employers were to look back over the prior 90 days of employment that the employee worked and then calculate, basically add up the amount, total compensation the employee received during the 90 days and divide that by the total hours worked by the employee for those 90 days to come up with a regular rate of pay. This clarification now that Governor Brown signed into law basically allows employers to use the same calculation that they use to calculate the regular rate of pay for employees during the work week for overtime purposes. So if they don't want to use this 90-day averaging method, they can use whatever method they have in place for calculating overtime. And also for exempt employees, employers can calculate paid sick leave in the same manner, or should be calculating paid sick leave in the same manner as the employer calculates the pay when the employee takes leave for other types of paid leave. And fifth, the law also clarified that employers are not required to inquire into or record the reason why employees take time off for the paid sick leave. There are the original record keeping requirements are still in the place, and just as a reminder, employers are required to document and keep records of the hours worked and the paid sick days accrued and used by the employee for at least 3 years. And the employees, as well as the labor commissioner, have the right to access those records. And in addition, failure to keep these required records creates a presumption against the employer that the employee is entitled to the maximum number of hours provided for under the law. So these clarifications are a step forward a bit, but there's still some major unanswered questions about the law. For example, does the law require 24 hours or 3 days? Or is it the greater of 24 hours or 3 days? It's not clear at this point. The DLSC has issued an opinion that it's the greater of 24 hours or 3 days, but the statute basically is silent on this issue. So employers are left to guess at the issue or the answer to this issue right now. So it's safe to play it cautious on that issue right now and basically grant the greater of 24 hours or 3 days. But again, the statute's not entirely clear on that issue. And also another major issue is when can employers ask an employee for a doctor's note? It's not addressed in the statute. And again, the DIR in their webinar earlier this year had said that if the employer asks an employee for a doctor's note, it could infringe upon the employee's rights under this law. But again, that's the DIR's opinion, and there's nothing specifically in the law that states out when an employer may require a doctor's note and under what circumstances the employer can require a doctor's note. So again, employers are left in this gray area regarding when and how they can require a doctor's note, and it should give pause to employers. You're not sure when and under what circumstances you can require the note. So again, employers should probably use caution on this and seek legal advice if they do implement a policy requiring doctor's notes for employees. So with that, I appreciate you listening in to the Employment Law Report. My contact information is on the screen. If you have any questions, feel free to reach out to me.